148th meeting of the Standing Committee on Citizenship and Immigration. The subject matter for the first hour is the supplementary estimates B, 2018-19, votes 1B, 10B, and 15B under the Department of Citizenship and Immigration. Thank the officials for returning. You were with us when the minister appeared, and we requested your return, and you graciously did that actually on the day we wanted it, so it's even better. We don't normally have opening statements, so I'm assuming there is no opening statement. The minister made the statement, and we'll immediately then go to questions on the estimates, beginning with Mr. Ayoub.
Point of clarification, Chair, before we start. How do you anticipate structuring the timing of the meeting today, given that the schedule's been disrupted?
I would like to give the officials an hour, if that's the committee's will, and push the next hour as far as we can until votes, so we can get the full meeting in. But I would like us to go, my proposal is we go 55 minutes now, which would be sort of normal, until 5 with the officials, if you're available, and that's okay. I know it's half an hour late. Okay, thanks. Mr. Ayoub.
Thank you, Chair. To begin with, I'd like to look at the Canada-Quebec Accord on Immigration. We know that the 2019-21 plan with Quebec could not include the immigration levels because there was a new government coming. There were elections, general provincial elections in Quebec at the time. The appropriation request for almost $70 million for the Canada-Quebec Accord. Given that it's less, does that have to do with the change in immigration that is planned in Quebec? Chair, no, the amount that's provided for this Canada-Quebec Accord in the supplementary B estimates is an increase in the accord. First of all, based on the number of non-Francophone immigrants that varies from one year to another, and also the federal expenses that vary from one year to another. This amount cannot increase or be zero. It has nothing to do with the level of immigration that Quebec has. So no matter what, no matter the modifications, the amount is always the minimum that's there. Is that right? Is that what I understand? Yes. The accord will have an agreement of 69.2, and that's 159 million annually, and it cannot decrease based on the accord. Based on the 2018-2019 period, there were voted credits of 712 of 112. I understand there was a supplementary round. Is that correct? What is the difference between the 79 million and the 129 million? 112 rather million. This was for the Canada-Quebec Accord. Chair, this was the amount from last year, 112 million, showing the number of Francophone, rather non-Francophone immigrants in Quebec between the previous year and the last year, rather. So there was an increase in the number of non-Francophone immigrants during those 2 years, and an increase in federal expenses. Every year is looked at in isolation. This year, if we compare 2018 to 2019, then we get this figure. Also having to do with the change in government in Quebec, we recently heard that Quebec has asked the federal government to not provide permanent residence, to go through with the last step of permanent residence, the permanent residence process, to almost 16,000 people, 16,900. This will decrease the total number of immigrants. What are the impacts of this decision for the department? And will that have an effect on the budget? Thank you, Chair. Between the Canadian and Quebec government, there is close collaboration on the question of immigration and management of the immigration file.
Government of Quebec in all aspects of immigration, and it is a shared responsibility between the government of Quebec and the federal government. L'accord Canada-Quebec.
The Canada-Quebec Accord is based on the principle that the governments must collaborate by setting immigration levels. Quebec has the responsibility of choosing the economic immigrants for its province and the level of economic immigration. So we work very closely, but it's really the Quebec government who decides which immigrants should come and the number of economic immigrants that will be permitted by Quebec. But with regard to the budget and the department, what is the impact, or what will the impact be, rather, because we don't yet know? There's already a ruling that requires Quebec to reopen the files currently. What will be the impact once this decision is made on the dollar amount and the relationship to the department? Answer. There are two financial impacts. First of all, what Mr. Mills already described, that is, in the context of the Canada-Quebec Agreement, Quebec receives money for immigration services. This is based on a formula that does not depend on the number of immigrants, but rather on federal budgetary trends. With regard to immigrant processing, we have a multi-year plan, an immigration plan, that is, and we try to increase other categories, that is, in other parts of the country, if ever the Quebec government reduces the number of immigrants. All right. So there's not really any budgetary impact for the time being. If there is, if the trend continues over several years, then perhaps there may be an impact on the budget. However, as it stands now, there isn't. Question. So normally there is not an impact on the accord. This is always the same amount. Okay. We're always often reminded, that immigrants and refugees, legal or otherwise, who come to Quebec, we're often reminded of their story, and we already know that Ontario and Quebec have spent a lot on them.
Well,
It's already
time
it
flies.
goes very fast.
Some excuse.
Next time, merci.
Ms. Rempel.
Thank you. It does fly. Thank you. I guess to Ms. Morgan, last week, Global News reported that your department had provided a briefing memo to the minister on January 18th, 2018, which stated that the Safe Third Country Agreement is no longer working as intended, and asylum seekers are evading the Canada-U.S. Safe Third Country Agreement by crossing into Canada between ports of entry where the agreement does not apply. This has brought to our attention gaps that may be creating a pull factor for people to cross illegally into Canada. So in that context, and in the context of the $114 million allocated for this issue in the estimates, has the government directed you or provided a date, an implementation date for any potential changes to the Safe Third Country Agreement?
Mr. Chair, as Minister Blair noted, the government of Canada has engaged with the United States to modernize the Safe Third Country Agreement, but I couldn't comment on any date by which time such modernization could take effect.
Okay, so there's no date yet in terms of when the pathway of entry into Canada, so sort of crossing illegally at Roxham Road. I know it had been speculated in the media today that what would be implemented is the RCMP would direct people to an official point of entry and they would be returned to the U.S. So your department has not been given any direction on a date in which that would start?
This is an agreement between two countries and will require extensive discussions between ourselves and the United States. And so I think it wouldn't be possible at this point to predict when a date for concluding any amendments to the agreement could be undertaken.
In terms of, as well, with regard to the modernization, there's been a lot of discussions about the phenomenon of anchor relatives potentially becoming an issue for people who have already entered Canada via this mechanism, that they may be able to allow people who, with a very broad definition of family, to enter Canada through legal points of entry. Has the government directed you or given you any indication that the definition of anchor relative would be changed per changes in the Safe Third Country Agreement?
I would expect that when we are in discussion with the United States on the Safe Third Country Agreement, that many issues could be addressed. Many things have changed since the agreement was first signed 14 years ago, including technology and biometrics and things that give us the opportunity to know who. To know who people are in a way that we wouldn't have when it was first signed. So I'm.
But specifically, the government hasn't directed you to look into any sort of policy changes with regard to anchor relative definition through the current, what we classify as the loophole with the Safe Third Country Agreement.
I would expect that once we have a better understanding of what the United States view is on the Safe Third Country Agreement, that a whole range of issues could be discussed. Certainly,
but not yet. That's not yet. Okay, that's great. The other question that I would have is the $114 million. From my analysis, is that largely retroactive, right? That would be for costs that have already been incurred?
That's correct.
Okay, so that's just to date. Has the government directed you to do any sort of analysis on the potential costs related to, it's my understanding that somebody who has a temporary status, so people who have entered Canada illegally at Roxham Road, claimed asylum, are waiting for their asylum claim, they have what we would call temporary status, correct? In terms of the interpretation on the Canada Child Care benefit, after 18 months, people with temporary status become eligible for the Canada Child Care benefit. Has the government directed you to do any analysis on the potential impact or cost related to giving Canada Child Care benefits to people who have temporary status but are awaiting their asylum claim to be heard who have entered at Roxham Road?
I don't have any information on that.
Okay, thank you. The other thing that I wanted to ask was with regard to the timing on the discussions with the Americans. So news has broken in recent days. Minister Blair has been out talking about this, that there's been some discussion. Has the government informed you of what the specific ask was to the Americans? So has the government actually asked the Americans to close the loophole, or is there a clear policy directive that you have been instructed by the government to investigate implementation as of yet?
As Minister Blair noted, we have engaged at a variety of levels in discussions with the U.S. We have noted to our U.S. colleagues that we think that this agreement is ready to be modernized and that many things have changed.
But is there a specific policy direction? Like I get that there's a lot of things, but he has come out and said that they are taking action. I'm just wondering what that action is, and if they have said anything to you with regard to a specific policy or how or when, just because we're looking at the budget, it's largely reactive and we're probably going to be asked for more. So has the government given you a specific policy direction yet?
And any changes that would be made to the Safe Third Country Agreement would have to be negotiated with the United States. It's an agreement between our two countries, and so no changes could be made unilaterally.
Has the government provided you with any desired changes that they are currently negotiating?
There are a wide range of changes
What are
that
those?
could be anticipated to the Safe Third Country Agreement,
Like what?
But those would have to be discussed with our partner, the United States.
But
who's
what has the
partner to
government
this
directed
agreement.
to you? I feel like the government, you must know, you're the deputy minister, one would think. So I would hope you would know, what has the government put on the table with the Americans?
Our objective is to continue our discussions with the United
nothing?
States in order to reopen the agreement.
Feels like you're
in order to
obfuscating, Ms.
modernize
Morgan.
the agreement. So
I'm
that
a
we can-
parliamentarian. and I would like some answers.
Excuse me, I would just remind the member that the interpreters need to interpret both parties, so if we could only talk one at a time. Thank you.
Well, interpret this. I feel like you're obfuscating, Ms. Morgan. There's $114 million on the table you're asking us to approve. What, if anything, is on the table with the Americans right now in terms of closing the loophole in the Safe Third Country Agreement?
Just to be clear, Minister Chair, the $114 million that is the subject of Supplementary Estimates B is primarily to assist provincial governments with extraordinary costs that they have faced.
I'll take that as nothing,
because
Chair.
of
That's
asylum
my time.
That's your time.
increases.
Mr. Rankin, welcome to our committee.
Thank you. And I am very, very sorry to announce that I'm not the regular member of this committee, but I'm well armed by Ms. Kwan with some questions which I'd like to pose if I may. I'm not sure who will field them, so I'll direct them to you, Ms. Morgan, and you can decide. The question she wrote for me to ask goes as follows. It concerns asylum seekers. In January, it was announced the government would be following up on the $50 million that was provided to Ontario, Quebec, and Manitoba to compensate for the impact on social services posed by the increase in inland asylum claimants. $114.7 million would be spent to help pay for temporary housing for asylum seekers. That was immediately criticized as insufficient. Despite hosting the second highest number of irregular border crossers that make an inland asylum claim, British Columbia did not receive a single cent of the original $50 million. There's yet to be any details released regarding how the $114.7 million will be spread across the country. So the questions: can you confirm if British Columbia will be receiving any of that funding, and if so, how much? When will the details be released publicly? And will funding be focused solely on temporary housing, or will the IRCC be listening to the experts and looking into ways to invest in more permanent solutions than shelters and hotel rooms?
Thank you, Mr. Chair. The Government of Canada recognizes that the increase in irregular border crossers has placed extraordinary pressures on some provinces and municipalities. The government has provided a total of $26 million to date to the City of Toronto to address the immediate temporary housing shortages in Toronto. We are actively engaged in discussions with the Government of British Columbia on the same issue, and certainly once those discussions have concluded, the government would be in a position to announce any arrangements that have been undertaken as part of those discussions.
So the answer is zero. And you're talking.
The answer is we're talking.
And the answer is zero, and you're talking. And yet you said nothing to the question I asked concerning whether there would be simply temporary housing focused, or whether you'll be looking at beyond shelters and hotel rooms.
Mr. Chair, we recognize that there are a range of pressures on both provinces and municipalities as the result of the significant increase in the number of asylum seekers. The funding that's provided for in Supplementary Estimates B is related to temporary housing funding. Federal government and provincial governments and municipal governments have all typically played different roles in this space and have provided different kinds of support in different ways. And so this funding in particular is related really to temporary housing.
So housing, hotel rooms and shelters, not what so many experts have been talking about in terms of more lasting solutions and temporary housing at issue. That's your answer, right?
Mr. Chair, I would note that the federal government has quite an extensive housing strategy. It's not within my ministerial remit, my department's remit, but considerable amount of funding is being put into building social housing in general.
Yes, but I'm talking about IRCC. I'm not talking about government-wide
No.
solutions. We're aware of that. We know it comes after the budget. I want to go to grandparents and parents sponsorship. This year, the government attempted a new system for the sponsorship program for parent and grandparents. This saw the interest to sponsor form cap hit in less than 10 months, with Countless Canadians kicked out of the application midway through or unable to open it at all. Has the IRCC undertaken a review of how this process went? Have ineligible and duplicate submissions now been removed? And will there be any need for a second application window like there was with the lottery system?
Mr. Chair, I'll turn this question over to Dr. Kochar.
Thank you, Mr. Chair. So just to answer that question, that we actually did use the electronic system for the PGP, and we had actually extensively done an analysis that this fits into the scheme of making sure that we are getting first in. And we tested the system that it can get the volumes, because from the previous historical levels, over 100,000 people apply. So we made sure the system is good. There are no duplications as such, and there is no anti-bot things like robotic ways of sending it. And also the system does not crash. So these were all done. We are at a stage, Mr. Chair, where we are actually looking through those applications at this point, and manually making sure that there are no duplications or incomplete, and then we will proceed from
So I hear you on the duplication issue, but I haven't heard you. I mean, it was notorious. It certainly made media in my city of Victoria that this cap was hit in less than 10 minutes, and then that was it. I mean, that surely isn't a success story. What are you doing to address it if you share my premise that it was a disaster?
Well, Mr. Chair, the popularity of the program and the people who actually want to get their near and dear ones in Canada, this is a very popular program. And certainly we expected a lot of people who would be actually coming in and trying to actually apply for that. We, to make it very clear, we actually posted all the information on January 11th. While we actually opened this on January 28th, everything was available, and it was expected that it will fill up very quickly.
10 minutes, sir? Was that a happy ending?
Well, this is how we cannot control the kind of input which comes in, and there are, as I mentioned earlier, over 100,000 applicants last year who were intending to actually sponsor. So there's a huge interest in actually getting the parents and grandparents here, and it is first come, first served basis. So as soon as the 27,000 limit was achieved, the system actually shut it down.
So is there a second window coming up?
We will have to actually look into it, Mr. Chair, to make sure that we have the requisite number so that we can get to the 20,000, which is the expected PGP levels for 2018. And if there is a gap, if we need more, then we will. But right now, it looks like we've calculated in such a way that we will stick with this particular number.
So there's no opening, no second window being planned at this time?
Not at this time.
Thank you. Mr. Whalen.
Very much. And maybe if I can continue, Mr. Kochar or Dr. Kochar on that line. Levels plan each year for the next 3 years anticipates a certain amount of family reunification. And I'm just wondering then, one would expect then that it'd be 20,000 the following year, 20,000 in 2020, 20,000 in 2021. So are there any anticipated additional costs or expenses expected under the estimates that we should expect with a 2019 round or a 2020 round, or is it likely going to be operated in the same fashion?
I'll ask my colleague, Mr. Mills, to actually answer the financial question, but I must make sure that we have the 2019 levels is 20,000, while we're increasing in 2020 to 21,000, as also in 2021. So there's a 1,000 person increase in there, because we understand that this is a very popular program, and we want to actually make sure that more people come in.
Well, maybe before, I'm not as interested now in the financial answer, because this is more interesting. So then, say for instance, from duplicates that are still being reviewed, you find that only 18,000 applications are in the pipe, and then so when you run the 2019 round and you open it up, will the computer software program allow us to open it up for those additional 2,000 people that were missed in the 2019 levels plan, plus the extra 1,000 people that will be in the 2019 levels plan to get 23,000 openings in the next round?
So I'll answer it in such a way, Mr. Chair, that just to make sure that we had 20,000, we actually accepted 27,000 this year. So we have the delta calculated. Should we have, and we have all the other things in place where we duplication is one, but bots and incomplete application, they would be kicked out in the very beginning. So we expect actually that we will have 20,000 or a little more, and we would be able to. Should we not have that amount, then we will have a discussion and make sure that we are actually able to have another round if need be.
Now, the levels plan target gives you a sweet spot at 20,000, but there was, sort of like a low and a high end target. So how will that affect then the next round of applications? And maybe if you could just confirm that we expect that next year's round of, or this year's round of applications will happen in the same fashion.
So, Mr. Chair, the parents and grandparents, as I would say, this is a little bit of a story where we have actually had a big backlog, which we've reduced to very minimal, around 30,000, less than 30,000 this year. Plus, we have actually reduced what was the wait time of over 72 months to basically now 39 months. And now going forward, if you apply today, 20 to 24 months. That's an approximate time. So if you reverse engineer it, Mr. Chair, what happens is that what we are actually receiving the applications this time, we will be actually landing them in 2020.
Okay, thank you. With respect to the estimates process, and maybe I'm back to you again, Ms. Morgan, and the Safe Third Country Agreement, I'm assuming that if there's any renegotiation of some aspect of the Safe Third Country Agreement that's going to cause additional cost, that would be budgeted and brought back to committee at that time. So, for instance, if there's going to be a program of transporting people and housing them on their way to a regular point of entry from an irregular point of entry for handing them back over, those costs in the budget associated with that type of a program wouldn't appear anywhere in these estimates. It's hypothetical, but it would be costed at some future date and come back to us in the estimates process in the next round.
Yes, it's reasonable expectation, Mr. Chair, that should there be costs associated with any renegotiated agreement, that they would go through the normal budget process with either main estimates or supplementary estimates, et cetera.
And do I have time for one more question, Mr.?
3 minutes.
Oh, okay, wonderful. Sorry, time is slowed down again. I expected in the estimates actually to see some type of indication on a project basis about this new rural and northern immigration pilot and costs associated with that. And also now there's been a renewal of the Atlantic immigration pilot for an additional 2 years. I'm wondering if you could explain to us, maybe this is a question for Mr. Mills, is on the financial side, but or not, why there's no specific explanation of the additional costs associated with trying to administer this pilot, because it's announced ostensibly in the context of Estimates B.
Well, Mr. Chair, the Atlantic immigration pilot and its extension, that is an initiative which we've been operating on within departmental resources, so just using the resources that we have, and also other federal agencies. For example, ACOA has been of great assistance to us in terms of administering that program, and also provincial governments have put a significant amount of resources as well, their resources, into administering it. So it's really been a partnership effort in order to make that pilot project work. And at the moment, we have not, in supplementary estimates, be asked for additional funding for the rural and northern pilot project. It's at the front end at this point, recently announced, and we have had our call out for proposals and received quite a few applications for that project. But we are not asking at this point for funding for it.
Within some other government departments, I think notably transport, they do project-based estimates on some of their programs, so parliamentarians can sort of have insight on a project-by-project basis. Is there any move within IRCC to do project-based estimates and appropriations so that we can have more visibility into that, or are you guys not in the pipe for that initiative?
We would normally use project-based management for example, major IT projects or that sort of thing. For example, a couple of years ago when we implemented the electronic travel authorization that was managed as a project, funded as a project, et cetera. But a lot of what we do tends to be an expansion of existing lines of business, and therefore not necessarily, we don't necessarily report on it to Parliament from a project perspective, if you understand what I mean. It's more volume driven in some.
And I guess that's it. Well, thank you very
7 seconds.
Thank you very much, Mr. Chair.
Mr. Tilson.
Mr. Chairman, I'd like to ask a question with respect to the $114 million that is being proposed to assist all of the provinces across the country as a result of the illegal border crossers. It appears from the provincial point of view that this isn't nearly enough. The province of Ontario has asked for, some time ago, $200 million. There was a story, I think it was in the Globe and Mail this morning, that the Attorney General of Ontario wants $45 million for legal aid, and she has pointed out that people aren't getting proper legal aid, particularly in front of the IRB. The City of Toronto has raised a concern repeatedly about housing. I think they're short about $45 million, and this is just Ontario. So the 114, in my view, at least if I accept the position of the provinces, and they're not making it up, is solely inadequate. So my question has the government directed you to consider increasing this $114 million to adequately assist the provinces and the municipalities to properly secure our border?
Thank you, Mr. Chair. We do recognize that the increase in irregular border crossers has placed extraordinary pressure on some provinces and some municipalities. We are committed to working with provinces to reach cost-sharing agreements, and we have provided funding both to. We have provided funding already, as I noted, to the City of Toronto. $100 million has been allocated for that purpose in Supplementary Estimates B. We recognize that provinces and municipalities have made the case publicly that their pressures are greater than that. At this point in Supplementary Estimates B, we're asking for $100 million to help assist provinces and municipalities with those costs. And we continue to have discussions with them regarding what the appropriate level of funding would be and how that should be operationalized.
Ms. Rempel.
Thank you. So there was two stories, Ms. Morgan. One was published by Global News. The writer was Amanda Connolly, and the other one was by CTV, Teresa Wright. And I think they're both referring to the same memo. I'm just wondering if you could clarify for us the date of the memo. So the memo that I mentioned earlier, the Access to Information request, where it was suggested by your department that the Safe Third Country Agreement is no longer working as intended, the quote that I read earlier. The Canadian Press story cites that it was written in January 2017, and the Global News story said it was written in January 2018. Which year is correct?
I don't have the memo. Oh, do you have it?
I'll check further, Mr. Chair, but I believe it's 2018 because that was in reference to the meeting that the minister was having.
So 2018. Okay, great. Thank you. That is very helpful. I just want to ask a couple of other questions outside of that. There was a story that was in the news a few weeks ago. It was on February 20th that an individual named Harjeet Singh was able to gain entry into Canada. And this, of course, he was deported from Canada 13 years ago because he had serious criminal allegations, including human smuggling. He was able to enter Canada again recently due to a letter of support from MP Raj Grewal. And I understand that your department has promised MP Judy Sgro that you would investigate this and report back to her why this could have happened. Do you have the results of that investigation?
Mr. Chair, I do not have the results of that investigation at this time.
Do you
Mind the member to try to at least loosely tie it to the estimates. Thank you.
Well, certainly the department spends a lot of resources responding to requests from MPs, so there you are. Do you anticipate when that investigation will be done? Ms. Morgan?
Mr. Chair, I would have to provide the member with the committee with information on this in writing because
Thank
I
you.
don't have the details that are
Thank
being
you.
requested at this time.
Thank you for committing to do that. I also noticed that IRCC is on the lobbyist registry for SNC Lavalin. It says they want changes to travel visas. What are these changes, and have you implemented them?
I'm afraid I won't be able to have you answer. Be sure and do your time. Mr. Sarai.
I'm going to actually carry on from Mr. Rankin and Mr. Whalen. I have a lot of constituents in my riding that applied for the parents and grandparents, and I'm well aware that in 2012 the parents and grandparents program by the previous Conservative government was closed down. It wasn't until I think 2015 that it was opened only for about 5,000 applications. Subsequently, we doubled it to 10,000. And then last year, I think 17,000. And I also understand 170,000 were left as a backlog. So I want to first of all thank you for eliminating most of that backlog and bringing the timelines. I think it was even longer than 72 months because I still have constituents that have applied prior to 2012 that are getting their parents and grandparents in now. So my estimate's that it's probably 6 years plus, maybe, so 72 to 84 months. However, many of my constituents, like you've cited and heard from others, missed the opportunity this year again, and we've tried the lottery, we've tried the courier system. Has there been any discussions in opening up the parents and grandparents program to a first in, first out line or queue, just like virtually everything else we have, whether it's spouses or others? You stay in line, and as you get processed, you come in. Because I think we have programs whereby we have the opportunity to bring your parents or grandparents in the interim, and that's either by a temporary resident visa or by the specific super visa for parents and grandparents. Has this been discussed? Is there any conversation? Because up until I think 2012, that was the way for decades.
Mr. Chair, I think that the challenge with the parent and grandparent program is, as Dr. Kochar noted, its great popularity, and that there are always, every year, many more people who would like to sponsor their parents or grandparents to come to Canada than we have space for in the Levels Plan. There have been different approaches taken to this. Prior to 2012, when there was no limit on the annual intake, the result of that was the creation of very, very large backlogs that took many, many years to resolve and had people waiting for a long time. Other ways that we have tried to deal with the difference between the number of people who would like to sponsor and the number of spaces we have in the annual Levels Plan has been, as the honourable member noted, queuing with couriers and first come, first serve that we did this year, the lottery that we did last year. So there are a number of ways to manage this issue. However, I think that the primary challenge here is really just the difference between the number of individuals and families who would like to sponsor their parents and grandparents and the amount of space, even though it has increased significantly over the last number of years, from 5,000 to 20,000 and increasing over the next few years. Nonetheless, there is not enough space in the Levels Plan in order to meet all of the demands for the program.
With due respect, I would argue that that was more of the case when the line was big, but the amount of intake was small, which built up a large backlog. With the rate you're going, it's actually been very fine. And even when you speak to those that have been waiting up to 72 months, they're not disappointed with that system. They're actually, they're patient with it. They get to bring their parents in the interim, either through a super visa or through a TRV, but at least they know they're in line. The current system, and I will say this almost with 100% feedback from my constituents, is not something that they like, because every year they're uncertainty. Year after year, they're either in line, 1 out of 5 chances last year, 1 out of 5 probably this year, or you don't even know because it got shut off. They would rather have certainty, knowing they're in a queue. They know it'll be maybe 2 years, 5 years, 6 years, but they have other avenues to come in the interim, rather than renewing a chance where if they're just an unlucky person, every year they'll never make the number. But if they have everything done, they've done their documents, then waiting is much better. And I think the previous system didn't work because the actual spots were being reduced and they weren't being filled, which built a backlog of 167,000. If you had 100,000 now, that's really because of the pent-up demand. And I think it would be appropriate to take that, and I think it's my duty as the Member of Parliament from Surrey Centre to give that information, relay it to you, and I think it would be almost unanimous regardless of the partisanship in this room.
I'm afraid I need to end you there. I'm not sure there was a question in there anyway, so I need to end you there. Mr. Tilson for 5 minutes.
Yes. Can you tell us what the current backlog is at the IRB for illegal border crossers?
The total backlog, Mr. Chair, is just about 80,000. I would have to look and see. You asked specifically the irregular portion of that, so we can look at that. But the total is 80,000.
And how many border crossers are still living in hotels?
0, Mr. Chair.
What's been the cost to date since the beginning of 2017 of housing illegal border crossers?
Mr. Chair, I would note that in the supplementary estimates B, there was $14.7 million related to temporary housing, but the vast majority of that at this point was used mostly for mostly at the border when irregular border crossers come across. There was about less than $2 million of that was used for the summer, that was used to assist the City of Toronto in managing the overflow in their shelter system in the City of Toronto. So about $2 million was spent out of this supplementary estimates.
What's the current wait time for a hearing before the IRB for the illegal border crossers?
Point of privilege, Mr. Chair.
I'm just going to actually say that the IRB is an independent agency. It's not in the supplementary estimates B, as I understand it.
What's the current rate of rejection of asylum keeper claims of illegal border crossers?
Point of privilege, Mr. Speaker. Yes. The member keeps referring, we've just witnessed a horrific act of terror in Christchurch, and the member keeps using this extremely inflammatory language. He knows what he's doing, and he just needs to use the right and proper terminology until such time as someone is determined not to be an asylum seeker. That's not the right language to use, and it's meant to inflame, it's meant to divide. And today of all days, he should not be doing it.
I'm going to suggest that that's a point of debate as opposed to a point of order. Yeah.
I would like to speak on that point, Mr. Chair, as there was a fairly big insinuation.
I don't think it. I've said it's not a point of order.
I have a point of privilege.
If you have a point of order or privilege,
I have a point of privilege because I would argue that was what was just said was almost to the point of slander. So my point of privilege is related to decorum, Mr. Chair, and that is a valid point of privilege under Bosch and O'Brien. I would argue a point of privilege.
The point. It's not your privilege that was being raised. It was a point of privilege with respect to your colleague.
A point of order on decorum, Mr. Chair. So my point of order on decorum is Bosch and O'Brien speaks to the fact that we are, as members, to maintain decorum at all times.
Keep the clock running.
And the reality is, Mr. Chair, is that what was just suggested, I think, is actually what leads to the rhetoric around immigration in this country being negative. It is perfectly valid to question the government on its processes related to immigration. The reality is that there are 40,000 people who have illegally entered Canada. There are large signs at the border that says it is illegal to cross the border, and then they claim asylum in Canada. Now, Minister Blair has been out today talking about the fact that apparently now they're talking to the United States about whether or not that would continue to be acceptable under this government or not with the American administration. So he is actually talking about that policy. To conflate the discussion of this policy and the terminology with a mosque shooting in New Zealand is both, it actually does speak to the decorum in this committee. I want to be very clear. What happened in Christchurch, New Zealand was a horrific act of murder and terrorism.
I'm actually going to ask the member
that-
to cease. This is now debate. It is not a point of privilege. I'm ruling on that,
it's
and
a
if you
point
may
of order.
challenge the
It's
chair.
a point of order, Chair. If I could.
No, it is not a point of order. It is
It's on
a
decorum.
process of debate, is my
It's on-
ruling as the chair. I'm happy to read again the role of the chair, if you would like me to. I'm ruling this is you're entering
It's a
into
point of order
debate,
on decorum.
and the
It is
committee-
invalid.
No,
it is.
it's
It's
not.
actually under Bosch and O'Brien. I can raise a point of order on debate
Mr.
or
Chair,
on decorum.
point of order.
I would like to finish. I will be very brief. I want to be very clear that I believe that this was an act of terrorism and murder that should be denounced. There's no justification for it. However, my colleague here just...
As the clerk has advised me, I have already ruled that there was a point of order raised that I have ruled as a point of, it was a debate issue. You are raising the same issue. I will equally say that it is debate.
Point of order, Chair. I'm ordering,
That's not such a thing as a point of order, madam. And you can challenge my ruling. I
A
am
point
now
of
ruling
clarification,
that
because
you
I
are
think-
out of order.
I think you've
I am now ruling-
misunderstood my point of order. My point of order was on decorum, and I was making my case respectfully to you that I believe that decorum has been breached in this committee, and I was laying that out respectfully and with evidence in very calm language, because I do believe that it is very important that we talk about this here. Okay? I would like to talk about why I think decorum has been breached, and I would like you to rule on that appropriately. All right?
I'm going to suspend the meeting for a moment and consult with the clerk. I'm going to call us back to order, and I will repeat what I have said, that to understand what happened here, Mr. Whalen raised a point of privilege, and I ruled that it was actually debate and did not entertain it. And so that ends the discussion about that. I have already ruled it out of order. You're asking me to rule it out of order because it is breaking decorum. I am not ruling. I have already ruled it out of order. And so it's now entering into debate about whether you like it or not like it. That doesn't really matter to me whether anybody likes it or not. It is simply, I have already ruled that it was inappropriate because it was not a point of order.
Point of order, a new point of order on decorum on your comment that you just made. You said that, and you claimed in the blues that or in the Hansard, that I was asking you whether I liked it or did not like it. And I would like to clarify that that was not my intent, and I would like to go back to the original point. But let me start with my now point of order. I don't believe that it is in the decorum of this committee for the chair to put words in a member's mouth. That is not what I said, Chair. So on that,
I don't think I quoted you.
You did, and sir, I would, with respect, what you are saying is not the point of order I was trying to make on decorum with the member opposite. So if you would let me quickly and briefly finish my point of order to you on decorum, it's with regard to general decorum in the committee. I will be brief, but this is not about whether I like or not like it. It's about
It was
decorum
whether
as
I
it relates.
liked it or not liked it. It didn't have anything to do with whether you liked it or didn't
You
like
said
it.
you, Chair.
it's about me.
I
If this
just,
is a new point of order,
no, I just, Chair, this is, okay, a point of order, going back to my original point of order, if I can make it so that you can then rule on it. It's a point of order on decorum in this committee with regard to how we treat the subject matter at hand. And the subject matter that we are debating today is the Supplementary Estimates B, and many of the questions today have related to the $114 million in Supplementary Estimates B related to the issue of people illegally entering Canada and then claiming asylum in Canada afterwards. Repeatedly, my colleagues opposite, from time to time, have issued objections related to that terminology. We can have a debate on that, that's fine. But where I believe the decorum of this committee was violated today was in the insinuation that somehow using terminology to question government practices was related to a very horrific incident in New Zealand. I don't believe, Chair, that as parliamentarians, if I may finish, and I will be brief, that
I've
that
already
is-
ruled that was an inappropriate comment because it was not. It was a matter of debate. I
But I
don't
would-
know.
I'm asking-
Other than making your point, which you've made, it is not a point of order. We have had a debate in this
But it's-
committee
it's-
numerous times about terminology. There are differences of opinion. I understand that, but I've ruled something is out of order.
But you're not letting me finish
You're
my
arguing
point of
with me
debate.
because I've agreed with you it's out of order.
No, you're not. I'm not arguing with you on this. I'm arguing that you have ruled that it is not, that his point of privilege was not valid because it was a point of debate. The point of decorum that I am making is that it is not part of the decorum of this committee because he had made an insinuation that questioning the aspects of this process was somehow related to what happened in New Zealand. And I just believe that we have to be very careful with making insinuations like that because it is insinuations like that that inflame and conflate debate and do a disservice and actually validate what that terrible terrorist did by raising it here in that way. So I believe that this was a valid point of decorum, and I would just ask if colleagues in here would refrain from doing that because we have a responsibility here. And I just feel, Chair, that this is.
I would ask the committee to please respect each other. We are in debate on this issue, which is not what we should be doing. There's a difference of opinion, and I would actually respectfully ask that we move on in the discussion. I don't think you were going to solve the difference of opinion on that today.
You can see that it's a valid point of decorum, and I would ask you to rule on it if you do.
I have never heard of a point of decorum in, I've understood committee decorum, but there's no such thing as a point of decorum.
Order on decorum. My apologies, Chair. So do you see my point of order as valid? And then I would ask for a ruling on it.
No, I don't, because I actually believe that I've already ruled it out of order. And to rule it out of order, I have said we will not entertain that debate at this committee at this time. And so I'm not going to rule that what I ruled was correct. I've got Mr. Tilson on the list, if you'd like to cautiously.
I'm never offended by Mr. Whalen and his charges to me, but I will say I'm repeating a word that was used by the minister in this committee who acknowledged that the word illegal and irregular are interchangeable. So, well, he did. He said it's on the record. I don't have the transcript with me, but I'm sure the chairman remembers, and some of you also remember. That's what he said. That those words are interchangeable, and I've decided to use the word illegal because that's what they are.
Mr. Chair, I think it's very clear.
I really think the
position.
debate is off.
All right.
And I would ask all members to address their questions to me, and when they're referring to other members on either side, please do it respectfully.
Mr. Chairman, I went to the department. Can you give us the numbers of the number of rejected claims of illegal border crossers to date?
Turn that over to.
Your time has come to an end. Ms. Zahid.
Thank you, Chair. I will share my time with my colleague, Mr. DeCoursey. So, yeah.
Just to start the time here, Mr. Chair, we just saw all three party leaders stand up in this House and talk about the importance of our words and our actions. We even had the leader of the official opposition stand, and I quote, say, "We must be as forceful with our words as we are with our actions." When my Conservative colleagues term people who would come across our border and seek refuge in this country as illegals, they are not matching their words with the actions we all asked ourselves to hold ourselves to today.
Debate as well. It's a very good debate that I think.
But I'm on time for question time, Mr. Chair. I would suggest to my.
Clarify, is this part of Ms. Zahid's time?
Yes, it is.
Okay, thank you. I missed that. Okay.
I would suggest that using words like illegal to describe those who would come and seek refuge in this country incites hate, it incites fear, it gives license to the type of white supremacist movements that cause terror to take root in our country and around the world. And I would ask my Conservative colleagues to cease using that word and to hold themselves to a higher standard.
Thank you. Ms. Zahid.
Thank you for coming today. My first question is that I note that there is $4.6 million request in the supplementary B related to biometric screening, which builds on another $6.2 million approved in the supplementary A's. So could you please discuss the impact increased biometric screening will have both on security and on processing times, and assure us that all necessary privacy steps are being taken to safeguard the data?
So thank you for the question. So biometrics, what we have rolled out
Point of order,
as
Chair.
such is basically a tool which we are using for enhancing the security, because this is what is used by many countries.
I have to interrupt you.
Thank you. Mr. Chair, my point of order relates to the Rules of Order and Decorum in Chapter 13 of Bosch and O'Brien. And I raise a point of order under the section related to unparliamentary language. This says that the proceedings of the House are based on a long-standing tradition of respect and the integrity of all members, that the use of offensive, provocative, or threatening language in the House is strictly forbidden, personal attacks, insults, and obscenities are not in order. A direct charge or accusation against a member may be made only by way of substantive motion, for which notice is required. I would argue, Chair, that under this particular section of the rules of our area, that what my colleague just did actually falls underneath that. That there somehow is an insinuation of intent with regard to the way that my colleague has correctly characterized the entry of people from the U.S. into Canada, that the Minister of Immigration himself has used, and that the Prime Minister himself has used. He has insinuated that somehow my colleague was inciting hate. I would ask my colleague to apologize for further inflaming a debate when we can all stand here.
I'm going to once again say that the member is moving into debate.
But
there is language that one side considered inflammatory and there's language that the other side considered inflammatory. This is then a debate about that. I did not hear name calling. I did not hear unparliamentary language. I simply did not hear that as unparliamentary. I think there's a list of things in precedent, and questioning someone because of use of a word is not unparliamentary. It is debate, however.
To clarify, though, I did raise my point under a direct or charge of accusation against a member, that it can only be made way of substantive motion. And I believe that my colleague actually made a direct charge.
And I ruled it out of order because it was not a motion, and that's why I ruled it out of order. And so there's nothing more I can do than have ruled it out of order, and you're continuing the debate, but this is a debate. It's not a point of order.
Thank you.
I'm going to go to Ms. Kwan. I'm going to use my prerogative and give you the closing 3 minutes.
Thank you very much, Mr. Chair. I'm going to ask some questions related to the Parents-Grandparents initiative. As the officials know, that people were cut off of the process 7 minutes into the process. Some people didn't even get to click onto the link. I wonder, why would that be the case when everybody has access to the link, everybody's sitting in front of their computer ready to click onto the link, and some people did not even have the link open to them? Could the officials provide us with an explanation for that, please?
Thank you, Mr. Chair, for the question. We have gone back to our own procedures. I mentioned earlier, this is a very popular program, so quite a few people were intending to actually sponsor their parents and grandparents. We provided all the instructions many days before the opening on January 28th at 12 o'clock, and it is a first-come, first-served basis. We tested our systems.
Sorry, I'm going to interrupt. I understand that process. But my question is this, in terms of the technology, if everybody has access to the link and they have it in front of their screen, and literally I have two constituents who had that in front of them. One person pressed onto that link and was able to get in. Another person was not at the same time. So how is that possible that people can't even get access to the link? And then furthermore, the instructions in the link tells people that they have 10 minutes to fill out the form. But some people were finished the form by 3 minutes, but they went back to review the form to make sure that they have got all their information correct. And then 7 minutes in, they were kicked out. So if they didn't go back to review the form, if they just sent in their form after 3 minutes, they probably would have gotten into the deadline. So then that's misinformation being provided to people who mistakenly thought they had 10 minutes to fill out the form once they opened the link, when in fact they didn't.
So, Mr. Chair, we actually put every piece of instruction for this PGP opening on January 11th, where we categorically mentioned that this is first come, first served basis. Nowhere is it mentioned in that we have a specific period of time. We also mentioned specific instructions that you will need to actually fill it with all the information, which you can also pre-plan, pre-prepare, as well as even instructions on if your lending documents are of bigger size than 2.5 MMB. We also posted the instructions how to reduce that. So making all those things available for the people to apply, plus testing the technology. We actually tested the technology with 30,000, 50,000, and 100,000 hits at the same time, and it did work in our pre-opening of this one. This was a testing which was done, and it did work. The technology did not fail us.
I'm afraid I need to end you there. Thank you. We're going to suspend. Thank our officials for attending with us today, and thank you for your exercise. One undertaking that I do believe I would like to have the committee get is that there was a number of 80,000 even though IRB is not in these supplementary estimates, I think it would be helpful for the committee to understand how many of those were irregular and how many of those were not irregular and what that is. I think that would be, because I think there's some myth about that, so it would be helpful to get some data on that. If you could ask your colleagues from the IRB to do that. We're going to suspend for a moment while we invite our other witnesses to come in. I'm going to call the meeting back to order and thank our officials from two departments for joining us today. This is the last part of our study on migration in the 21st century, and the committee had some questions, particularly around temporary foreign workers and the relationship between the way the two departments work on this through LMIA as well as the TFW program. And they wanted to close off probably with some questions about how that works and just to clarify some of the things that have been said by others, mostly outside witnesses. Are there opening statements? Yes. Yeah. So the opening statements, who would like to go first, IRCC or ESTC? What makes sense?
Maybe wider.
Sure. I can start.
So we'll start with Mr. Cashback and IRCC, and then go to Ms. Alexandra and Mr. Massey.
Great. No, thank you very much, Mr. Chair, for inviting us to speak as part of your study on the migration challenges and opportunities for the 21st century. Je suis directeur général par intérim dans la Direction générale de l'immigration.
I am Acting Director General of the Immigration Branch and at IRCC. With me is Helen Panagos, Director of Temporary Resident Programs Operations, and Paulette Lefebvre, Director of Biometric Program Operations.
Commencer en reconnaissant l'importance de l'immigration.
I want to begin today recognizing the importance of immigration fostering economic growth. We've heard that from many Canadian stakeholders and businesses about the need for skilled labor to grow for their businesses, improve exports, and create more jobs. In addition to strategies for enhancing the participation of the domestic workforce, IRCC recognizes that new immigration is an important component to meeting Canada's current and future skilled labor needs.
Population, and that more workers are leaving the workforce than are entering it every year. As such, immigration will be a key source for population and labor force growth, accounting for 80% of labor force growth by 2031. For today's meeting, I'll be speaking about what I understand, as you mentioned, Chair, the main areas of interest, that is, programs that facilitate the temporary entrance of foreign workers to the Canadian economy, as well as our processing and issuing of work permits. There are two distinct programs under which foreign nationals can work temporarily in Canada. The first is the Temporary Foreign Worker Program, which is designed to support employer efforts to fill labor and skills requirements when qualified Canadians or permanent residents are not available. This program is administered by Employment and Social Development Canada, and my colleagues here will discuss it in a few minutes. The second program is the International Mobility Program, which facilitates the entry into Canada of foreign nationals whose work brings broader social, economic, and cultural benefits to our economy, or maintains reciprocal opportunities for Canadians to work abroad. It is under this program, for instance, that we do facilitate the entry of business persons under various trade agreements and youth under international exchange programs. Regardless of the program under which foreign nationals seek to work in Canada, however, most will require work permits in order to be authorized to legally work in Canada. Les permis de travail peuvent être délivrés par nous-mêmes à IRCC.
Work permits may be issued by either IRCC or at a port of entry by the CBSA. Our department recognizes the importance of predictable work permit processing so that businesses can develop concrete plans as to the arrival of foreign workers. As part of our departmental service standard commitments, IRCC aims to process 80% of all work permit applications submitted outside of Canada within 2 months. From April 2017 to March 2018, IRCC met the service standard 89% of the time. The service standard for work permit extension applications submitted in Canada is to process 80% within 4 months. For the same data range, IRCC met the service standard 97% of the time.
Innovations and Skill Plan. The Global Skills Strategy was launched in 2017 to facilitate faster access to top talent so that innovative companies can grow, create jobs, and contribute to Canada's economy. As part of this strategy, IRCC provides expedited 2-week work permit processing to select foreign nationals in management and professional occupations. Since its implementation, we've approved just over 21,000 work permit applications under this initiative. We continue to receive positive feedback from stakeholders and employers that this expedited processing is generating real benefits in terms of attracting foreign talent and investment to Canada. That said, we recognize that processing delays can occur. Our ability to meet our service standards can be affected by a variety of factors, such as seasonal volume fluctuations and factors beyond departmental control, such as incomplete applications or the need for applicants to submit additional information in support of an application. While we remain committed to the prompt processing of work permits, we also wanted to acknowledge that we continue to ensure that foreign nationals that are authorized to work temporarily in Canada do not pose a safety or security risk to our country. In support of these efforts, we have implemented a mandatory biometric screening requirement for all foreign nationals who apply for a Canadian work permit. By collecting these biometric data, we are able to quickly and efficiently validate an applicant's identity while also identifying security risks. Our biometric policy is among the most generous in the world. To facilitate repeat travel to Canada, applicants for a visitor visa, study, or work permit will only need to give their biometrics once every 10 years. Monsieur le Président, j'espère que mon intervention d'aujourd'hui vous aura permis de mieux comprendre.
Mr. Chair, I hope my remarks today have provided some insight into the facilitation of temporary workers into the Canadian labour market and the associated process of work permit processing. I thank you for your time and look forward to your questions. Thank you very much.
Monsieur Massé ou Ms. Alexandre? Monsieur Massé.
Thank you, Mr. Chair, for the opportunity to present on the Temporary Foreign Worker Program. I'm the Director General for the program at ESDC, and with me is Katie Alexander. She's Executive Director for Program Operations at Service Canada. Le programme des travailleurs étrangers temporaires a pour objectif.
The objective of the program is to provide employers with access to foreign workers on a temporary basis when qualified Canadians or permanent residents are not available. It also aims to ensure that foreign workers are protected when in Canada. In 2018, ESDC approved approximately 108,000 positions under the Temporary Foreign Worker Program. That's a very small footprint in the labor market. Less than 2% of all Canadian businesses use the program, and temporary foreign workers comprise less than 1% of the Canadian labour force. However, it is very important to certain sectors that tend to face recurring labour shortages, including agriculture and agri-food and tourism. For example, about 64% of temporary foreign worker positions in 2018 were in primary agriculture occupations.
Continue to have first opportunity at available jobs. Employers must submit an application for a labour market impact assessment before being permitted to hire temporary foreign workers. Applications are reviewed to ensure the employer and job offer are genuine and that the employer has been in compliance with program rules and applicable labor laws. Applications are also assessed against a number of labor market factors to ensure the hiring of a temporary worker will not have a negative impact on the Canadian labor market. Among these, the employer required to demonstrate that they have advertised to and recruited Canadian and permanent residents, for example, through common online platforms, including Canada's Job Bank. And their efforts must include efforts to reach out to underrepresented groups. Further, the onus is on the employer to explain whether and how the temporary foreign worker will have a positive effect on the local labor market, either by filling a labor shortage, transferring skills and knowledge to the local labor force, or supporting job creation and retention of Canadians. Finally, employers must also certify that the hiring of a temporary foreign worker will not lead to offshoring or job losses for Canadians or permanent residents and will not negatively affect the settlement of labor disputes. It's also important to note that to prevent suppression of local wages, employers are required to pay temporary foreign workers at the prevailing wage rate in their occupation and region. Service to clients is a key priority area for the government. The program is committed to continuously reviewing its operations to ensure that it effectively balances the need to provide employers with timely access to workers with maintaining the thoroughness required in the assessment of employer applications. So primarily due to a tightening of the labor market and beginning in April of 2018, there's been a 26% increase nationally in the number of application volumes received from April to February compared to the same period in the previous year. So this is resulting in longer processing times recently. Service Canada is making every effort to provide the best possible service to employers and is processing these applications as efficiently and accurately as possible to minimize the impact on employers. Now, recognizing the urgent nature of the labour shortages across Canada, ESDC recently reallocated $3.4 million across all regions in Canada to handle the increased number of applications and reduce processing times. Service Canada is also reviewing its current processing to find new and better ways of service delivery for the program. In particular, Service Canada is considering or already implementing a number of measures to increase the quality, consistency, and timeliness of assessment, and is engaging with industry stakeholders to ensure their input is taken into account when developing policies and systems. This includes, for example, reduced administrative burden for seasonal agriculture worker program employers by allowing multiple arrival dates on a single application. We've launched a national quality monitoring program in December 2017 to improve the consistency in decision-making and processing applications. In November 2018, the program was streamlined to focus on key critical factors, reducing the amount of time a review would take by approximately 2 hours. In addition, the department has implemented a workload management strategy to help maintain consistent and timely decisions across Canada and will be piloting a new online platform starting in spring 2019. To conclude, ESDC and Service Canada are committed to continuing to improve the efficiency and timeliness of the delivery of the program to ensure that it works for employers, workers, and the economy. So I'd be pleased to answer your questions.
Thank you very much. Ms. Zahid for 7 minutes.
Thank you, Chair. My first question would be for IRCC. I would like to draw your attention to the presentation Statistics Canada made to our committee on February 28. In 2 charts, they showed how the labor force participation gap between the immigrant men and their Canadian-born counterparts has narrowed over the years and is pretty much on par by year 5 after landing here in Canada. The situation is different for women, however. The gap is as much as 20 points for newly landed immigrants, and even for those who have been here for 10 years or more, there remains a stubborn gap in labor participation compared to Canadian-born women. While there can be cultural differences, I know many immigrants who want to work but face barriers, or who are underemployed in positions beneath their skills and the education and skills they have. Are you aware of this gap, and can you please tell us what specifically the department is doing to increase the participation of immigrant women in the job market?
Sure. Thank you, Mr. Chair. I think it's an area that, thank you for drawing our attention to the Statistics Canada study. I think it's an area of that gap is something that we like to make sure that we are sort of monitoring. I'd sort of point us to, I think the settlement program at the department is one that we do use to target to immigrants and refugees in order to sort of really help them find and retain employment. That's the key. That's the key. You sort of mentioned it as years after landing is it's a big measure for us in terms of knowing whether the program is successful. Employment-related services help overcome some barriers. I think we do expend quite a bit of effort in terms of making sure that, all things being equal, language skills are supported, that we're able to sort of bolster a newcomer's professional networks through supports such as work placements, mentorship, employment counseling services, and job matching services. So I think on the settlement side is an area where we really try to deploy the resources to sort of try to address and make sure that newcomers here have those opportunities and are getting those outcomes.
No, my question was that are there any specific programs for women? Because for women that gap exists, but the men are narrowing that gap as they get into 5 years of being here in Canada. So are there any specific...
Just to be fair to the witnesses, they came to talk about temporary foreign workers, and that's what they're prepared to discuss. I'm just wanting you to draw that into TFWs or LMIAs because that's the topic for today. It isn't about wage gaps and those things. And just to be fair to the witnesses, they came prepared. And I know Mr. Cashback has some overall responsibility, but not really in this area. Am I correct?
Yep. No, you're absolutely correct.
If there can be some information which can be provided to us, that would be fine.
I don't think that's fair to this branch to do that. I think that is for our settlement services study. I don't think it relates to today's meeting. So I'd ask all the members to try to keep us on track about temporary foreign workers and LMIAs. Thank you.
Thank you. My next question is also in regards to the Statistics Canada data that job vacancies and unemployment rates vary across economic regions, with Atlantic Canada and certain rural regions reporting higher job vacancies. So could you discuss how the Atlantic Canada Immigration Pilot and the Rural and Northern Immigration Pilot are helping to encourage the new immigrants and the other programs which we have for the people with the temporary foreign workers to settle in these regions with a need for skilled workers?
Sure, I'm happy to. I mean, I think a lot of those programs that you've mentioned, so the Atlantic Immigration Program, something that we've had in existence for 3 years now, is one where they are permanent immigration programs. I mean, the objective is really to try through some new approaches in terms of working with employers, with personalized settlement plans to ensure that a permanent resident will be interested and sort of motivated with the supports that he or she needs to remain in the Atlantic. I think retention was a big question that we had around the Atlantic Immigration Program. I think we're trying to build on that with the Rural and Northern Immigration Program, realizing that the specific labor needs in those rural areas is fairly, they can be fairly specific. So looking to here partner with employers, but also with local economic agencies to try to increase that, let's call it stickiness, and the value that a community can put forward in terms of attracting and retaining newcomers in their labor markets. But I'd say, they are primarily addressed to attract and retain folks as permanent residents.
Do I have time? There have been some additional 2,000 spaces have been reserved to increase the pathways to permanent residency for temporary foreign workers in NOC-C occupations beginning in 2019 under the provincial nominee program. So can you explain the motivation for this move and why it's important to ensure that both workplace vulnerability for workers is reduced and that a pathway to permanent residency is available when employers are trying to recruit people in markets where people with these skills are in demand?
Sure. Maybe on the first, Mr. Chair, the announcement last week of the introduction of 2,000 new spaces under the provincial nominee programs. So we've distributed these to all of the provincial nominee programs to give a bit more space to transition temporary foreign workers, so folks that are there that we require in the labor force, and retain them as permanent residents. I think that's one thing where this is really an initiative that's aimed to meet those regional labor market needs in some key sectors that the provinces, through their programs, will help determine. I think that's one thing, of course, to sort of ensure that pathway. In terms of your other question, or the other question in terms of worker protection, that's an area of a lot of activity between both departments that are there to ensure that there are protections in place for migrant workers, for temporary foreign workers that are there, from provision of information to also some regulatory changes that the department is considering, that the government has put forward to.
I'm afraid I need to end you there.
Course, yeah.
Mr. McGuire.
Thank you, Mr. Chair. I want to thank the witnesses for their presentations today as well. I have a number of questions, and I'd like to table some information that I require, Mr. Chair, if we can. I don't know if we'll have time at the end, or do we get another round?
You may. I'd like to end. We're going to go about 20, 25 minutes over, and I think that's probably pushing, so you may not get another round.
So
but
I'll just table
you
it.
might want to get them in there.
Okay. So to Mr. Massey, thank you. Just wondering about my background's in agriculture, and so I'm just wondering if you think there's or if there is, and according to your information, currently a labor shortage in the agriculture and agri-food industries.
Well, it's well known that the program is a recurring source of labor to ensure that employers there have access to the amount of labor, and certainly their reports to us, and in terms of the program requirements, the advertising that they must do, the recruitment that they do demonstrates that they have difficulty attracting a local labor force to fill those jobs. So I think in a punctual annual basis, you would agree that there is a labor shortage there, and the program has been improving 2/3.
Yeah, thanks, Mr. Chair, and just in relation to time here. But when I read the EDS labor market information, it shows that that there isn't, there is not a labor shortage in agriculture, and so I just wondered if you can explain that. The economic contribution to agriculture is like over 300 million a day, 111 billion a year. So do you think that the EDSC should recognize the ag and agri-food shortages and prioritize the temporary foreign worker program?
So it depends which type of data you're looking at and the type of analysis that you're looking at. So if you're looking at some of the projections that the department does produce, these are 10-year projections, so they would look over a very long time what the expected shortage would be. These are very low skilled occupations, and so in that type of long-term meta-analysis, they would show that markets would tend to balance over a long period of time. Yeah. Of course, our program is we're looking at the situation year over year, and so those are the assessments that we're making. Well, and so those are the types of differences in the types of data that that exist.
I don't want to say it's a misnomer, but I certainly the terminologies are there, but I'll just use an example. The critical shortages for butchers in the meat processing plants is horrendous right now. And so what are the service delivery standards and timelines to process their applications for those in companies who have to pay $1,000 a worker, such as slaughterhouses for butchers? Can you give us an idea of the timelines?
Yeah, for sure. So we are currently, as Mr. Massey mentioned, experiencing a higher than normal volume of files. So 26% increase over this time last year, which has resulted in a delay longer than expected for most compared to this time last year. For a low wage stream, we're looking at a processing time of approximately 90 days at this point. So agriculture is a little bit faster. It's about 40 days, and our seasonal agriculture worker program is about 15 to 16 days.
Yeah, that's not been my personal experience. I've got farmers that have waited 6 months or more to get regular farm laborers. I mean, the on-farm agriculture has got the highest vacancy right now. It's about 7%. And there's farmers and companies are going to see the gap grow in years to come, they're telling me. So why are farm workers and butchers not on a priority list for the IRCC when some other industries may be? I mean, what can you do to make that more of a priority to shorten that length of time? Because, they're going to be going to the fields here in a couple of months, or maybe in some areas of Canada within a month.
So the truth is we want to make it shorter and more efficient for everyone. And in particular in agriculture, we know they have a recurring need every year. And this year has been particularly an eventful one given the introduction of biometrics. So we've actually taken steps to facilitate that process, have them apply earlier. We've given them opportunity to apply for multiple arrivals on one application. Even in the current backlog situation, we are prioritizing, within those applications, the seasonal agriculture worker program, recognizing the need. And so we're doing everything we can. We're continuing to look at the process to make that more efficient over time, going to an online system this month. So we're managing through the glut this year, but we're trying to make it efficient for all employers to get through the program.
Have you ever considered a temporary or like a trusted employer program where if you've been bringing in the same seasonal ag workers for years and years, we can have we don't have to go through this.
Yep, that's
70 or 100 or 200 workers' names every year?
Yep, thanks for the question. That's something we are looking at currently. So the idea would be sort of a Nexus-like program for recurring employers that we know that are in compliance with the program, and so how can we facilitate the processing there? Yes.
And another area is the audits and inspections. I've heard some real horror stories from some of the farm areas in regards to how Service Canada has treated the farmers in audits. And the inspections process. I want to know how we can improve the inspections that are, more responsive and transparent. I'll give you an example. One circumstance that I know is one auditor exclusively worked on one audit for 6 months and refused to share even the most basic information with that farmer. And the EDSC held up his applications even when even after they denied that they would. And he was. These are industries that are very susceptible to perishable goods, fruit, vegetables, this sort of thing. And, 6 months can put a person out of business. So I just wondered what you're doing in that regard and if you can look into that.
So certainly highly sensitive to the impact of inspections going to have on employer operations. I mean, the goal of the inspections is to ensure that employers are compliant and that the rules are being followed and that workers are treated well, and that's the ultimate goal. That being said, these are new processes that have been put in place in the last year and a half, and so it was, I think, some growing pains to begin with, and the departments acknowledged that some improvements, and we've been engaging much more with the sector to identify those issues, communicating better what the requirements are and what to expect during an inspection, and to actually improve our communications between our inspectors and our processing folks to ensure that we're not needlessly holding up applications. And applications will only be held up if there's suspicion that there's some abuse happening in the workplace. So we don't hold up applications if it's administrative verification or confirming data. It's really about when somebody's at risk or in danger of becoming of harm. So
I'm afraid I need to end you. Did you have something written you'd like to?
I do, Mr. Chair,
Okay.
and if I could give you these pages of questions that I have just to have answered, and I would turn these into the clerk as well.
Give the clerk,
just
yeah.
to,
I think it would be
to have them
helpful.
answered. Yeah, okay. Thank you, Mr. Chair.
I'm just going to take one little minute and you'll still get your time. What I'm having trouble with on this is I've met with agri-food people, food processors, who are talking a crisis level in terms of employment shortage. And so those application numbers go up, but instead of getting them faster, we actually get them slower. There's not intelligence we can use, and I don't mean smarts, I mean some kind of a system, an algorithm that says when we start to get this increase, whether it's in an agri-food business, that actually the process should go faster instead of slower. And what seems to be happening in my head is it goes slower when it's more urgent because there are more applications. And can't we improve that?
Well, yes, we're looking to improve, the processes. The reality is we're funded to a certain level, and so we don't have more people to bring to the...
No, I would actually take fewer people and say, it just makes sense that I've got 17 canned peach producers. They're looking for people to work in the processing. You stop evaluating it in the same way and say, it's obvious they have a shortage. Right. Let's fast track them like a Nexus program. Does that take... I don't think it takes money. I think it takes a different way of doing it. And is that a legislative change or a program change or a regulation change or a mindset change? I'm exasperated by it because
I understand.
I'm getting employers all the time saying, we have a labor shortage.
I understand. So the labor shortage aspect is only one aspect of what we look at during the application process. So we must assess the genuineness of the employer, whether, this may be involved in a labor dispute. So there's some things that we need to verify regardless of what the labor market situation is. So the labor market is only one factor, and those things take time. And as I mentioned, there are efforts to try and streamline, including looking at a recognized employer for those that we see on a recurring basis. Can we assess them differently? It's not about bending the rules, it's about expediting some of those assessments. So those are some of the things that we are working on currently.
You've been very good, so I'm going to give you more time.
No, it's just a quick one, Mr. Chair.
Well behaved.
Handed in about 3 pages of questions there, and so there's an urgency, I guess. I just wanted to get a reply back on those as quickly as we can, because I believe we're starting to do the report
soon, yeah.
ASAP.
We'll try our best again. Ms. Kwan.
Thank you.
Thank you very much, Mr. Chair. Mr. Ayub agrees that I've been very good too, so I should get extra time as well. Okay. So on this question, I have this question. If you have a reoccurring environment where these temporary foreign workers are required, in some instances, I've met workers who's come for the last 20 years for these positions. Instead of making them temporary positions, why not make them into permanent residents on arrival for these workers, as opposed to going through a temporary process? Clearly, there's a need and has been for the last 20 years. Is that something that the government's looking at or your department's looking at?
Maybe that's more for the immigration side of the House. I think this, the short answer, I mean, where we're managing volumes on the temporary side, it's managing then with the levels plan, the annual levels plan, and setting out sort of per category of immigration what the priorities are, and it's a numbers, like not to be trite about it. It's a bit of a numbers game. You know, who and what priorities exist.
Well, yes, I know it's a numbers game because the levels plan numbers is exactly just that. But clearly, we've had witnesses who's come forward from the agriculture sector, from the tourism industry, from other sectors who say we need these workers. We want them to stay, by the way. We don't want them to go away because they have to go back to retrain them, and which costs them money as well. So they are now actually calling for permanent residence for these workers. So I would urge that this be a priority for the government. And maybe in order to robbing Peter to pay Paul within the levels plan numbers is to increase the levels plan numbers. In fact, the former minister, John McCallum, did exactly that study, and through that expert review, the business community and others are saying that we need to increase our levels plan numbers, and yet we are still struggling to get there for some strange reason. I would urge that this be considered for the department to do a review of this policy and to say the pros and cons, to say what needs to be done and how to address this issue for both the economic aspect, but as well as for the building of Canada as a nation aspect. Has that work, by the way, and has that work been done, or is it work that has not been considered?
No, I think as part of the suite of programs that we do have, when I look at 2017, 50,000 former workers, temporary foreign workers, transitioned to permanent residence. So that's the highest ever number in terms of that of those transitions. So you sort of look at the suite of programming that exists, from different work permit programs to then. We were talking about the Atlantic immigration pilot, but also the proposed rural and northern immigration pilot, in terms of how do we try to create those conditions to be able to either retain workers that are already there or attract workers into communities where there's a labor shortage. So I think there's a lot that's been done, and there's things that are being proposed now. To try to address the issues that are being
I
raised.
think for the very fact that you have those high numbers of people seeking permanent residence only goes to show you the fact that you should actually begin this process as a permanent residence status program as opposed to a temporary program. Because you actually save, I think, a lot of resources from the department side that you can reallocate to something else and somewhere else to deal with backlogs. And like, wow, wouldn't that be great for business and for Canada and for your department's workload? I'm going to leave that for a minute. I'm going to ask the question about the recent program for caregivers. It was announced that the caregivers will now be pre-vetted, and they would be pre-vetted before they can come to Canada. And then once they come here, after they fulfill their 2 years work requirement, they would then be able to access their permanent resident status. So for clarity, does that mean to say once you have been pre-vetted and you have fulfilled your 2-year work requirement, those caregivers will then be given their permanent resident status, or do they have to go through another application process? Will they have to go through another medical process? Could you expand on the procedure and policies that's required for these individuals with this program?
Sure, I'm happy to, Mr. Chair. I think there's a lot of the detail that will be announced at a later date, but in terms of what's for the new pilots that will be introduced later this year, what we have learned, and this is sort of based on a lot of the input and the consultations that we've done with stakeholders and caregivers over the last year. One thing that we heard in a lesson that we're trying to learn with these programs is the pre-vetting. It's the sort of subject.
Sorry, I'm going to. I know I was part of those consultation process and worked very closely with the caregivers. But what I'm interested in, though, is that what does this mean now that this announcement has been made? The caregivers, actually, just a couple of weeks ago, I was at their meeting. They were asking me, what does this mean now? Does that mean to say once I've been approved for my pre-vetting, that I will, after my 2 years work requirement, be able to stay in Canada? That I would not have to go through yet another process, another vetting process, whether it be medical or otherwise, to get my lander status. Does it mean that?
The medical exam I don't have for you right now. What I will say, what we do intend with this is to have language and education, everything really but the work experience assessed before they even come to Canada, to sort of create that clarity that once a caregiver is here and they've done their 2 years of work experience in the professions that are being considered for the pilots, that then they're eligible for permanent residence after that 2-year period.
Right, and then would they have to submit another application to get their permanent resident status? Or is that assumed within the pre-vetting?
I think that it's assumed in the pre-vetting is that, I mean, the application forms and all of the information will be made public later this year. So I think in terms of the actual nitty-gritty, it's something that we'd be happy to sort of come back to the committee, and we'll be engaging with caregivers and stakeholders later this year in terms of the specifics of how that program will look like. But
when do you expect to know the specifics? The government went and announced it, and you don't know what the specifics are. So when will we know then what the specifics would be?
Later this year.
Later this year, but you don't have a date, like a month.
I don't yet, no.
I see. Okay, so with respect to, with respect to then the caregivers program, the people that are in the system at the moment, so the people who have already arrived here but not yet met their 2-year work requirement, there's the intern program, can they apply simultaneously? So that is to say, still hold their place in where they are right now with the program, and then make an application under the intern program. Can they make 2 applications to see which one gets processed first?
Very briefly.
Sure. I mean, I think the best advice that the department's provided to caregiver community is to not apply once, do not apply twice. Has been the advice. If a caregiver qualifies for the existing pilots, right now those are not. They haven't reached their caps. They're being processed in 6 months. The interim pathway that was announced and is now accepting applications, that application period will be longer. It will be 12 months. So if somebody meets the current criteria, they should apply.
About 8 minutes.
Okay, I'm not asking a question. I wonder whether or not, Mr. Chair, that I think the entire committee would benefit from a briefing from officials on both the intern program as well as the temporary, the replacement programs, because there was some sort of briefing offered to people to phone in, but we weren't actually, my staff couldn't even ask a question in that process, and I think this would be of benefit to everyone.
I think it's a very good idea. It's outside the study. I think we could do it as a standalone briefing. We could do it at a committee meeting. I think it would be helpful. Yeah, I think we'll note that and try to schedule that. Could I would consider that a motion. We'll just take that as a motion. And are all agreed to that? Yes. Good. Could I just, you said something in your testimony, it caught me by surprise, about the number of temporary foreign workers who had got permanent residency. Could you just repeat what you said? Because it was a new number and a new thing that I just want to make sure we have correct.
Yeah. So looking at the number of looking at the multiple pathways that a temporary worker has to stay permanently, when we sort of look at the number of workers who transition to permanent residence, looking at 2017, 50,000.
50. I thought it was 15. Okay, it's 50,000.
Transitioned in 2017. So from a status, whatever it was, as a temporary worker to a permanent resident.
And historically, that's unusual, or
there's been a rise. I don't have the historical data. We're happy to sort of.
I think that'd be helpful for us if we had some kind of a historical picture on that, because it was news to me. Mr. Tabera, for about 5 minutes, and then we'll be done.
Okay. Thank you, Mr. Chair, and thank you for witnesses for being here. I just want to read a little bit about this article that came in the spring, and I'm just going to read a bit of it. It's a CTV news article. The title is, "In Canada, Labor Shortage is the New Norm." Canada's small and medium-sized companies must find ways to adapt to a new norm of workers' shortages that will likely persist for a decade, says Pierre Clairaut, Chief Economist for the Business Development Bank of Canada. The BDC survey of 1,208 people from small and medium-sized businesses with at least 500,000 in annual sales found 39% of them were having difficulties hiring the types of new workers they required. I just want to get into the global skills strategy. we initiated that about a year and a half ago, I believe now. Can you tell us about why we brought this initiative in? And I believe in your testimony you said that we've allotted 21,000 work permits of foreign talent. Is that correct?
To come back to the 21,000, that's it's not an allotment. It's the volume that we've seen since the program was introduced in June 2017. So since June 2017, 21,200 work permits have been issued, approved under the name, under the sort of the banner Global Skills Strategy.
So if I'm reading this article here, and it was talking about the labor shortages, has the Global Skills Strategy been successful in closing the gap on these shortages?
I think it's Mr. Chair. It's definitely one of the it's one of the tools that are in the toolbox. I think when we talk about between temporary and permanence, the Global Skills Strategy, you sort of in your introduction, I think one of the reasons the GSS was put in place is to really create the conditions for companies to access the top talent they need when they needed it. Hence, the pillars of the Global Skills Strategy: 2-week processing for certain workers, dedicated service for firms and employers in order to attract that investment and attract that business to Canada.
So you just mentioned in your answer here is top talent. So if the Global Skills Strategy is getting the foreign workers, talented workers to work in, for example, my region in the high-tech sector, what are we doing about workers, skilled workers, whether they're in the trades? I hear often individuals in my riding that, we're really short in the skilled trades, whether it's electricians, millwrights, plumbers, pipe fitters, etc. Employers are often applying through the LMIA program, but they're often seeing that it's cumbersome. It takes a lot of time, and I do understand that we have to advertise to ensure that Canadian workers have access to these jobs first. But if we have such a gap in the skilled trades, is there any room to refine the LMIA program to see if we can speed up skilled workers that can come into this sector, so we can reduce the gap, similar to what we've seen with the Global Skills Strategy? Sorry for a long preamble.
No, that's fine. One thing I didn't mention in my remarks or my answers, we do have some categories that are allowed some priority 10-day processing. One is those coming under the Global Skills Strategy, Global Talent. But there is also priority processing for skilled trades as well. So there's a list of, I don't know how many there are, 20 or 30 trades that would be eligible for 10-day processing. They must still submit an application, and it still must be reviewed, but they will be prioritized, under the current policy.
Okay. Can you send the committee just a list of those trades? It would be very helpful for us to consider that in future meetings as well. That leaves me to 4 minutes and a half. Are we?
It'll take 2 minutes.
more
You've been
minutes.
well
Okay.
behaved too. You and Larry.
My last question. Pardon?
If you want.
Did you, Nick? Did you want?
Yeah.
I'll let Nick go in.
With respect to, we've been all dancing around this, but this whole notion of labor market impact assessments being needed for industries where it's already clearly known that there is high labor market demand, and generally there's high labor market demand across all sectors, and we would really prefer Canadians get the higher paying jobs rather than the lower paying jobs ultimately. And so I'm just sort of wondering what sort of changes would need to be made to the rules to put more of the opportunity with employers to determine their own labor market needs and remove some of the bureaucratic and time-consuming hurdles that are preventing it. What legislative changes would we need to make in order to fast-track workers into the country in lower-skill job areas?
Well, you need to change the regulations to remove some of the requirements that employers must meet in order to be able to access the program. I think the thing to remember is the program's purpose is, yes, to provide access to employers, but it also must be balanced against ensuring that Canadians have opportunities for those jobs as well. And so what's the appropriate test is ultimately the thing that Canadians will look for in ensuring that those Canadians have access to jobs.
It's our understanding from previous testimony that actually the number of jobs created per immigrant is actually net positive. So just by allowing immigrants to come in and take jobs actually creates more jobs. So if you bring in 10, you'll create an extra one for a Canadian anyway. So I'm just sort of failing to see the logic on why we even still adhere to this sort of non-evidence-based requirement for labor market impact assessments at all.
Good point.
Okay, sorry.
Yeah, no real problem. I'm going to give Mr. McGuire a chance. Do you know, this may be an unfair question, what year those regs were written? It just feels to me like they were written in a time that's not like today.
I think the basic regulations would have come in at the time IRPA was written. I don't know exactly what year that was. There was significant reforms brought to the program in 2001.
And the labor market has changed dramatically. I'm 18 years older, and like we're all older now. I mean, I'm sensing something that we're going to have to do in this report that says that something needs modernizing here. I'm going to get both Jenny and Ms. Kwan and Larry.
Thank you very much, Mr. Chair. I wonder if you can indulge as well this request. It would seem to me that it would be beneficial for the committee members to also get a briefing from staff.
I just need to, I'm sorry, these are now unexpected bells.
What?
It was pushed back, and now it's back. Okay, can we have 5 minutes for Ms. Kwan and Mr. McGuire?
Yeah, sorry, I was just going to quickly add to say that I think the committee would benefit also from a briefing from staff on the rural community pilot as well, the pilot program that the government announced. Because I think that there are some issues as well that we as members of parliament would like to bring up. For example, I live in City Vancouver.
Point of order. We are required immediately in the House. That's what's the message we have. All members in the House immediately.
Yeah, but it's a 30-minute bell. Is it a 30-minute bell? Yeah, 30-minute bell. But does that mean I don't have unanimous consent to continue? I hope I do for like 3 minutes to get, Ms. Kwan has just made a motion, which I think is an appropriate motion, that we get a briefing not only on the new caregiver program, but also on the rural pilot. All agreed? Okay, well, we'll schedule it. Mr. McGuire, bring us home.
Mr. Chair. It's in relation to my colleagues' good questions on permanent residency and temporary foreign workers. I'm just wondering, is there a pathway to for the permanent residency for temporary foreign workers now? I think that's if there's a pathway there, I mean, the minister's mandates letter indicate that they were going to look at it and do it, and just wondering if you could expand on that, and if there is very shortly, I guess, answer that question. Is there a pathway to permanent residency for temporary foreign workers now?
Sure. Thanks very much, Mr. Chair. I think there are definitely many in existence. I think when we look at the announcement last week around the additional 2,000 NOC spaces under the provincial nominee programs. I think that was one of the key mandate letter deliverables in terms of increasing those pathways to permanent residence. But I'd say that across a number of our permanent immigration programs, sort of foreign workers are always eligible to apply, and I'd add that sort of experience working in Canada are things that gets 1 points under the express entry selection system as well. So that is sort of recognized and that always encouraged.
Stuff, yeah.
Okay, I think the meeting is adjourned. Thank you very much to the officials.